Afternoon, dear ladies and gentlemen. Very happy to see so many of you here in this room. My name is Nikolaus Forgó. I'm here today mainly for the housekeeping because the content will be provided by many other high-level experts in the domain. Let me, however, express at the beginning my gratitude and my happiness about this being possible today here at these premises of the law school. And let me share with you some of the background information about why we are doing this and why this is such a happy day for me. So the main reason why we are doing this is this, which is one of the two books that I had the pleasure to co-edit together with Ceyhun sitting here in the very first row and Peggy Valcke sitting here at the panel. And those of you who ever did something like a book editing process know how much time it needs to produce something like this. And I must also confess that it's not the first time in my life that I did something like this, although this is probably the largest project ever undertaken. What I want to emphasize, however, is that this is the most positive editing experience I ever went through. And I did some of them already for two reasons. First, because Ceyhun and Peggy are, when it comes to the brute facts, outstandingly brilliant experts in their domain. And second, perhaps even more importantly, because it's such a pleasure to work with them. We had endless meetings every week working on this project together. We didn't meet in person any day before today. So it's literally the first day we saw each other in person. And it was outstandingly nice to do this. However, when you do this, of course, you find many topics that need further debate. So each of those books or such books is just a starting point for the next book or the next project to write and to edit. And that brings me to the second reason why this is such a pleasant event today. It's because of our authors. So there are about 90 people who contributed to this volume, many of them being present today, be it on the panel, be it in the audience somewhere. And those authors guarantee, in my view, first, that hopefully this is somehow state of the art at the moment, but hopefully it will also be a starting point for some of the most urgent and some of the most recent discussions that we have when it comes to AI and regulatory questions. We took two of those questions, which are possibly the most important ones and the most urgent ones today, to go more into detail. And I'm very much looking forward to contribute to a debate that will hopefully end up in a similar publication in the very near future. Let me just, if I may, introduce some housekeeping rules today. First, this event is streamed and it's also recorded on YouTube, which means that if you don't want to be online visible, the way to do this is not to raise your voice, because we are just streaming the panel, not the background. However, if you want to contribute while we are still online, feel free to do so. But please wait until you've got a microphone, because otherwise people won't hear you. Those of the audience who are not physically present. As it might be that some of the aspects that we are going to discuss are a little bit sensitive for some people in the audience. We do know that we have people from regulatory authorities here, lobbyists here, stakeholders here, etc. As we know that it might be that not all of you want to share everything with everybody, there will be a clear cut made after the first round of questions and answers, where we will stop the stream. And from then onwards, we will use a Chatham House rule here in this room, which means that in principle, things that are said here can be shared with the outside world. It would be naive to believe that everything stays here inside, but please, without naming the source. So if you want to share something in the second part of the debate with somebody, feel free to share the content, but not the source. We will then have a coffee break and then a second round. And then again, the same rule will apply, which means the panel is streamed. There will be a stream part of the debate somehow, clear cut Chatham House rule. And then we will hopefully have altogether a cup of coffee or wine or glass of water, whatever you want. We do have some resources over there. Please feel free to help yourself also now if you want, whenever that is convenient. Let me finish this just with another very warm thank you to those who are running the show here today from the department side. So this is, of course, our two moderators, Clara and Adriana, whom you will meet here, and two people very much in the background, on top of quite some other people in the background. This is Martin and Hande just standing over there in the back. Thank you to all of you, and thank you to all of you for making it here. Very much looking forward to the discussions. Have a wonderful afternoon. I hand over to Clara. Thank you.
Thank you very much, Nikolaus, for this very nice introduction. I'm really happy to moderate the first panel on AI governance, and we'll start by introducing our speakers, and then Mr. Steinmaurer will provide a keynote on AI governance, followed with a discussion on AI governance, and then the Q&A with you. I'm really happy to present Klaus Steinmaurer, who is our keynote speaker for the first part of this event, and who is currently the CEO of the Austrian Telekom and Postal Regulatory Authority. After his master and his doctorate in law from the University of Vienna, Klaus also completed a master's degree in IT and business process management at the Vienna University of Economics and Business in 2010. After some years in a construction company, he joined the first private mobile operator in Austria, beginning his career in the telecommunication sector as head of legal and regulatory affairs for T-Mobile Austria, now Magenta, and in 2016 became vice president of the International Regulatory Affairs Europe at Deutsche Telekom. In 2019, he became Austrian Telekom's regulator. And besides all of this, Klaus also has a part-time academic career with several publications concerning digital and telecommunication sector. Most recently, also being an editor of the main commentary regarding the Austrian Telecommunication Act of 2021. And lastly, he is also one of the authors who contributed to the EU AI Act commentary, notably on the Article 21 cooperation with competent authorities. And for our two panelists, I'm really happy to introduce Elisabeth Wagner, who is Deputy Head Commissioner of the Austrian Data Protection Authority. She studied law and anthropology at the University of Vienna before joining the highest administrative court as a scientific employee, where she focused on asylum law and building law or disability employment, to name a few. And in 2014, Mrs. Wagner joined the Austrian Data Protection Authority, initially interested with national litigation, procedure with the framework of the data processing register, approval procedure for international data transfers, as well as European agendas. And since the adoption of the GDPR, she shifted her focus towards European and international affairs by being appointed head of the International Affairs Department in 2023. And Professor Peggy Valcke is co-director of the Center for IT and IP Law at KU Leuven, executive board member at the Belgium Institute for Postal Services and Telecommunications. She studied law at KU Leuven and completed a degree in European competition law at King's College. After obtaining her PhD degree with a dissertation at the crossroads of media, telecommunications, and competition law, she became a research professor and gained significant experience in international projects while supervising research and teaching. In 2020, she joined the executive board of the Faculty of Law and Criminology as finding research and of the KU Leuven Institute for Artificial Intelligence, and served as co-director of the Flemish Expert Center on Data and Society until 2023. She also worked as an advisor for European and Flemish officials, and as an assessor judge in the Flemish media regulator and in the Belgian competition authority. And she also holds the function of executive board member of the Belgian Institute for Postal Services and Telecommunications this last year. And last, but certainly not least, she's one of the 3 editors who put together and coordinate the EU Artificial Intelligence Act, a commentary for which this event is taking place today. So thank you very much to our speakers, and I will let Klaus now proceed with the keynotes.
Good. Dear audience, dear co-authors and of our new commentary of the IAC, dear colleagues from other authorities, dear colleagues here in the room. First of all, thank you very much for allowing me and give me to give this keynote address at this high-level event today. This is truly a great honor for me. For the sake of good order, I would like to preface my presentation with the following. As there are still no designated authority available, I have to make it clear that everything I will say below on issues regarding AI and governance represents exclusively my personal view on things and can therefore not attribute it to RTR GmbH, the AI Service Center of RTR, and the commissions supported by RTR. Just to make that clear, that's important, and thank you for understanding. While the topic of this event addresses both the importance of AI literacy and for each of us, as well as for companies and organizations, and the relevance of a balanced governance system, my keynote will focus on the AI governance. AI literacy will then be the topic of my colleague in the second part of this event. So I'm deeply convinced that the AI Act, and with it the GDPR, let's call it the mother of digital regulation, are much better than their current reputation and can play a decisive role for Europe in the competition of the future. If we know what we want to achieve and we also recognize the opportunities that lie in the regulations and make proper use of the tools defined there. AI literacy will have a key function there, and that's the main part of this year. Governance is the necessary legal framework to ensure secure and successful competition. The real problem with the use of AI and innovation through AI is not regulation, but uncertainty, distrust, and ignorance. AI governance, which takes into account also cross-functional coordinative responsibility, plays a crucial role in this context. But for those who think that regulation is generally, you hear it often in the media now, the regulation is generally devil's work. It is simply easier to fill the media with claims like over-regulation, hostility to innovation, and to argue that every other economy than the European Union is much better than to look at the benefits of regulation, especially a flexible governance system for everyone in this context. Trying to understand existing regulation and trying to utilize the given tools in favor of competition and consumers is not an easy task. But if we, as lawyers, academics, and regulators, can deal with the regulations of the AI Act intellectually and are able to translate the whole thing into the language of the users, then the whole can become a success story. Artificial intelligence did not just fall from the sky recently. It has been a subject of research for many decades. There have essentially been two approaches or methods. One is the so-called symbolic or logic-based AI, and the other is the method of the machine learning, in which results are obtained from large amounts of unstructured data using statistical probability. The first approach took a precedence for a long time because it led to comprehensible, well-structured results and is closer to the structure of theoretical computer sciences, but is only very slightly scalable, which was also one of the reasons why the topic of AI received little attention in everyday perception for a long time. Perhaps you know we had this AI ice age in the 80s. So that was this where nothing happened, nothing was looking at that. So that is this time. The second, the machine learning approach, together with the corresponding marketing strategy, then brought the breakthrough with OpenAI and ChatGPT in 2022. Suddenly there was something that looked very interesting, but we didn't quite know what to do with it. The main objective of the European Union when drafting the AI regulation was therefore to create the most flexible regulations possible to promote the use of AI in the internal market and ensure that everyone has the same opportunities to utilize the advantages of AI in competition, while at the same time being obliged to comply with the rule of law, ethical values, and fundamental rights. The Commission was aware of the dangers posed by AI and therefore chose this well-known risk-based approach in order to leave sufficient room for product innovation. In the Commission draft from April 2021, the governance system was not yet given the importance that we now find in the final regulation. The AI Office, Article 64, you know, in its current form did not yet exist. This changed when the merge of ChatGPT and OpenAI and etc. at the end of 2022. The new governance structure is intended to promote the introduction of human-centered trustworthy AI and thus innovation and investment. Looking a bit on the other parts of the world, China is also aware of the necessity of an AI regulation governance and has developed a comprehensive and detailed regulatory regime in recent years. There are two ethical as well as practical aspects of technology development are taken into account, and importance is attached to appropriate governance. The United States, we know, will also have to consider that in the international competition, although it's to be foreseen that a rather fragmented regulatory system in the field of AI can be expected there, at least under the current administration. Now coming to governance and regulation. At European level, it is clear that comprehensive governance regulation is required in order to enable meaningful and targeted implementation and application of the risk-based AI regulation in the AI Act. Digital regulation, I'm really convinced about digital regulation without appropriate structures to ensure a secure and fair legal framework and for effective enforcement can therefore not be possible. This is not only recognizable in the context of the AI regulation. In general, in digital economy, a trend can be observed, the European level can be observed, that points to the desire for regulatory tasks to be more strongly centered around the European Commission. National regulation and the possibilities for national regulatory authorities to influence European regulatory agendas are increasingly receding into the background. Essentially, the relationship between the European Commission and the national regulatory authorities centers on the exchange of information and advice. When you're going through Chapter 7, you see it's more the exchange of information and advice, nothing more. The concrete strategy and decision-making authority has largely shifted to the Commission. This should not come as a surprise, but understood as a result of the digital markets, which are no longer national, but are rather economically and geopolitically located in triangle USA, Asia, and Europe. Europe would therefore do well to attempt a standardized regulatory approach in order to avoid falling further behind in terms of competition. Overall, it is therefore not yet possible to identify a standardized governance approach for the digital markets. Overall, you know, we have all this a lot of digital acts in the past 5 years, so therefore there's no standardized governance approach seeable actually. However, this is desirable at least in the medium term. Comprehensively harmonized digital regulation that enables uniform European governance for the development of digital markets as a third pillar, alongside general competition law and data protection law, will ultimately be competitive advantage and not a disadvantage, as is often claimed. A prototype model for such a digital governance could be the dual governance structure set out by Chapter 7 in the AI regulation, which pursues a two-stage concept and attempts to provide a broad range of decision-making instruments involving all relevant stakeholders for flexibility required in the digital sector due to the often still lacking experience in individual cases. Coming back to recital 148, This states in the first sentence, this regulation should be established as a governance framework that enables both coordination and support for the application of this regulation at national level and capacity building at union level, and the integration of stakeholders in the field of AI. To this end, the governance rules of the AI Act in Chapter 7 are designed to ensure that civil society, the scientific community, and national regulators are involved as broadly as possible before far-reaching decisions are made. At national level, Article 70, there's basically a great deal of flexibility as how the authority structure is implemented. The model set out in Chapter 7 is for sure not perfect and is certainly complex and harbors, we all know and we have discussed about it, it harbors a number of risks. The next steps will show how and whether these risks materialize, but it is important, that's I'm convinced about that, but it's important to start, work, learn, and create the structure for envisaged in the AI in the union and national level very soon now. Now I'm coming to a very important point in this context, is the AI Act and the GDPR. In order to ensure the correct and successful application of the AI regulation, it is important that this is done in accordance with the General Data Protection Regulation. As I already said, the mother of EU digital legislation, so to speak. As expressly stated in the AI regulation, the provisions of these two legal acts apply in parallel, emphasizes by the fact that the regulation is based on both Article 16 and Article 144 of the Treaty of the Functioning of the European Union, which for sure does not make things easier to handle. That's clear. In this context, some experts blame GDPR and data protection in general are an additional regulatory hurdle, once again preventing AI innovation. The statements that are repeated by CEOs and financial market experts like a prayer wheel in the public are already familiar to us, I think. My opinion on these arguments is a bit more nuanced. AI and personal data naturally have a lot in common. Despite all the supposed intelligence, however, it cannot be assumed that large language models all the large language models of this world concisely evaluate whether data available to them is personal or not, and whether everything they are asked to learn is GDPR compliant. GDPR must be considered independently of the obligations arising from the AI regulation. The challenge is that certain assessments can often only be made independently on the basis of each legal provision with only minor difference and characteristics. And nevertheless, it's clear that GDPR is fundamentally technology neutral, which is a bit different on AI. Where at least personal data may be part of the processing GDPR applies, it will not be easy to fulfill the requirements of Article 5 and Article 6 of the GDPR, especially when it comes to data minimization, storage limitation. We have a central point of conflict between AI applications and the GDPR. Large language models are about using as much data as possible for as long as possible, which in itself is a contradiction to data minimization and storage limitation. Another problem is the requirement of data accuracy, because while AI works with statistical probabilities, for example, it tries to offer the most probable solution possible, the GDPR requires that data used must be factually correct and, if necessary, updated. And in particular, that it is deleted if it's incorrect. With a narrow interpretation of requirements under the GDPR, the AI applications concerned are at least at risk whenever personal data may be used. And that's one of the big problems we have to face now. It therefore seems appropriate when training AI models to ensure that original personal data is anonymized or pseudonymized as far as possible before processing by AI for this purpose in order to avoid the application of the GDPR. Particularly, it is important to deal with the individual requirements step by step and above all, to discuss them with all the affected stakeholders, both in regulatory area and with users, and try to define and further develop a regulatory framework precisely as possible ex ante. The GDPR, therefore poses fundamental challenges for AI applications that need to be harmonized with the objectives of the AI regulation and the economic expectations placed on the application. AI expertise in the institutions company presupposes GDPR expertise. We shall keep that in mind when talking about digital and AI literacy later on. As complex as this may sound, recent regulation is an opportunity to develop practical and sustainable solutions. It allows us to build legal certainty and trust for investors, which is particularly important for AI applications and will become increasingly so. This, even although some slight adaptations and/or legal clarifications seem appropriate in the medium run. The keyword confidence building is also a good sign to briefly summarize what has been achieved so far and to call for the next steps. Not just about sidestep to competition, the rule of law and legal certainty. Having the necessity of AI governance in mind, I want to address in this context also the following. The internet, we all know, was just the beginning. The functioning of the internet was and still is a matter of trust. It is about ensuring that as many people as possible trust this technology. And the internet never should be a legal black hole as some proponents of the digital Wild West would demand. AI regulation and AI governance particularly should enable competition. I'm convinced that healthy competition is an important corrective between good and bad offers, between good and bad at the end. But regulation should also ensure that the rule of law and democracy are not damaged by unintended use of just developing new technologies. Ultimately, the rule of law is also an important decision criterion for investors, and we should accept the existing AI regulation as an, I would say, important step towards providing an investment innovation-friendly framework in the digital sector that will allow us to compete. Even if it's not perfect, AI regulation together with GDPR are the two important pieces to have the legal framework needed to secure and expand European competitiveness. And I mean that really with full conviction, despite all those who claim the opposite and fill the media with it. These positive outcomes of existing AI regulation will not happen overnight, but if we implement it consistently, it is the right way to go to harvest the fruits of the near future. The worst thing Europe could do now would be to buckle under American pressure and abandon the path it has already taken. Then we will be out of the game. Just let me finalize now with a short call for action in this context. From the perspective of the practical regulatory tasks ahead of us, I would like to emphasize the following here at the end. AI governance as a framework and guideline is, in my opinion, essential to making AI a success story. As recently expressed at the AI Summit in Paris at the beginning of February this year, we are only at the beginning and the race for the best places is certainly not yet decided. And it is not the time now to be shaking with fear due to the harsh words of towards the European digital regulation by the American Vice President there. AI regulation certainly has its weak points, but on the other hand, if properly understood, it is also a great asset that can provide legal certainty if applied and interpreted appropriately, and can therefore make an important contribution to innovation and investment and competition. There's certainly room for improvement, but AI Act and GDPR are our tools as lawyers, regulators, and academics, and we have no better ones. We have to use them. That's what we have to be in mind. We will all have to still have to learn a lot, and we will still make many mistakes, but we must dare to do so. So if we want to be successful and make our contribution to the digital future of our continent, not imitating the US in their Wild West manner and banning regulation without a plan, but doing a sustainable, innovative, and ethical business based on the rule of law is very important. Digital competition is, and that should be clear for all of us, digital competition is not a protected workshop. It's AI regulation offers us an initial framework and a direction. We just need to have the courage to use them and to do things right. And therefore, that's what we are doing now here in Austria. Perhaps most of you know it, where we are working on, and perhaps that I can say yesterday, it was also said that based on this, we will play a future role also in the AI regulation and governance here in Austria. That's part of the program of the upcoming government for the future. So let's see how it will develop. So that's this in this case. As said, digital regulation, AI governance is not a protected workshop. It's on us to make the right thing out of it and to make us successful. And therefore, I want to thank you for your attention. Wish you a successful, very active and interesting afternoon. Thank you.
Thank you very much for this very insightful keynote. And I will now let the floor to Elisabeth and Peggy for a few minutes on AI governance and any thoughts you would like to share with us.
Yeah, thank you. Thank you for the invitation. I'm really honored to be on this panel with these esteemed guests. I must have a disclaimer as usual. I'm talking from the enforcement side, which is a really practical side. We have to work and enforce the thing, as was said, enforce the GDPR and maybe also something from the AI Act. So I must confess that Dr. Steinmaurer I must have seen his keynote before, because most of my speaking points are already covered by this really nice speech about GDPR and the AI Act. I can sign everything that was said. That was really positive. It's nice to hear something positive about the GDPR and the AI Act, and so optimistic. As was mentioned, I maybe repeat something a little bit to have it, to imprint it in your minds. As was said, the GDPR is unaffected by the AI Act, and personal data in our opinion, plays, of course, a major role and sometimes a major role in the AI system. So we're still competent and have to deal with systems that process personal data. And of course, I know this is also disputed, and there are many, many different opinions on that. If it's really personal data, if it's really, is it really data of a data subject, or is something that is produced and a new product of this AI system? So I will not give answers on that because I will just mention it. So up until now, our authority is designated as a fundamental rights authority within the meaning of the AI regulation, which means that we play a role in the examination of other market surveillance authorities when personal data is involved. And there are intensive talks, and I'm quite happy that there is a new government, finally a new government in Austria. So the AI Act in Austria can be really implemented, and also the market surveillance authorities are designated. We think and this is no surprise at all that we think that we might, I mean, if it's not yet written in law, but things can happen, of course, but up until now, we think that we are competent for certain things in Annex 3, according to Article 74, Para 8 AI Act. So we will act as a market surveillance authority. And we will have to face these challenges. And what is really important is that we gather the knowledge. What we see, and I'm talking from a really practical level, is that we as we are working with the GDPR and we've gathered knowledge, but we have to understand the topic. And so what we do in our authority with the staff, we have no additional staff. So with the people we have is to gather as much knowledge as we have, and from an enforcement perspective, the knowledge and also the technical expertise on this topic will be important and crucial for us. And it will be important for all the market surveillance authorities to have this kind of expertise. And this will be really difficult also because there are not many experts yet. And it's really important also from a government side to be attractive to these kind of experts, to really get them. And we're really lucky that we have in our staff, we have many people that are really interested in AI, and we also have like applicants that are really coming to apply to us because of AI. And I know from other supervisory authorities that really people are coming with the expectation to have something to do with AI in this is offices. What was all some mentioned, and also on the European level, we are, of course, the ETPP, we already had a lot to do with AI. We issued an opinion on certain questions, but what was also mentioned by Klaus Steinmaurer is this interplay between GDPR, and I want to have some few words on that too. I can really sign everything that was mentioned. There is a difficulty at data accuracy, Article 5.6, that will have to be decided in the future. The courts, and to have like a legal certainty, there will have to be some decisions on the interplay of this, because of course GDPR is you have the data correct. But the question, and the main question will be, and also it was already a complaint lodged with the Austrian SA by NOIP on data accuracy, and we really, I mean, it's a cross-border case, so it's really, it will be really interesting to have the outcome of this case, because this is actually the first is the first case who really deals with this kind of questions, to my knowledge. Maybe, you know, somewhere else a case was lodged. And this will be really, really interesting also for us from a GDPR perspective. But what is really important to have in mind when you speak of GDPR and the AI Act is the different goals, the different purposes of these two apps. GDPR is a regulation dealing with the fundamental rights. It has the goal of the GDPR is the focus is the data subjects and the obligations that controllers have to fulfill in order to process personal data. The AI Act also has some fundamental rights in it, but it's a product safety law. So it's something, I mean, it seems similar because also if you look at the chapters, it's quite similar, and there's also like processing record and something like that. And in the beginning, you have like all the definitions and definition of AI, which is really interesting and really difficult. I read it several times, and and maybe you too, and it was really, really interesting. I guess that maybe lawyers and technical experts have had like their fingers in this kind of definition. And but it's a product safety law. It's something, the goal is to have principles in the European Union to say what AI should be and what AI should not be. What AI do we want in a democratic society with human rights, and is like a risk-based. I see a risk-based approach. There's also some risk-based approach in the GDPR, but the GDPR is applicable to all, whether you're a small entity or you're a big entity. And there are some, there's only a few articles that have something like a risk-based approach, but the whole AI Act, as I understood it, and as I see it, and we see it at the authority, is like really like, do you have an AI system that is forbidden? Do you have a high-risk AI system, or do you have like a regular AI system? And then, according to that, the obligations are quite different. So I think my 5 minutes are over, so I leave you with that, and maybe I will add something then during the discussion. Thank you.
Thank you very much. And I will let now for her introductory statements as well and sharing some thoughts.
Thank you very much, Clara. I'm also thrilled to be here. Thank you for the kind words at the start, Nikolaus. Also from my side, I'd like to stress that this whole book editing experience was one of the best in my life so far. So thank you for the excellent collaboration, both to you and Cheon. Of course, I would like to continue on the positive note that we heard so far about both the GDPR and the AI Act, despite all the criticism that has been voiced lately, I guess, especially by the tech sector, that we are over-regulating in Europe, that we're not innovating, but only regulating. I disagree. I will come to that. I think in my introductory notes, I would like to perhaps make 3 points and focus on the national governance or governance at national level. And I guess it boils down to keep it simple where possible. So my first point was actually what Elisabeth said towards the end. The AI Act is primarily product safety law. So its main legal basis is Article 114, to a limited extent, Article 16 of the Treaty on the Functioning of the EU, Recital 3 of the AI Act clarifies this. So it's mainly product safety legislation. And in existing product safety legislations, there's this strong tradition of by design requirements. So embedding important values, safety, health considerations, embedding that into technical standards. That's the bread and butter of the existing market surveillance authorities in sectors for toys, elevators, medical devices, and also radio equipment, something at BIPT for which we are responsible. So your GSM, a mobile phone, that's a radio equipment. There are checks whether this equipment complies with safety standards, with privacy standards, that there are technical standards for that. And this market-oriented approach of the AI Act is reflected in the chosen enforcement architecture, which is entirely based on the new legislative framework, as it is called. That's Regulation 2019-1020 on market surveillance and product conformity. So my first point is basically when designating MSAs, market surveillance authorities under the AI Act, it is important to have MSAs which already have that experience. Second point, also already pointed out by Elisabeth, the AI Act does not affect, but complements existing rules on product safety, as I already mentioned, but also very importantly, data protection, GDPR and the like. But also consumer protection, cybersecurity, fundamental rights, employment, worker protection, etc., etc. So all the rights and the remedies that are provided by these rules for consumers and other persons for whom AI systems may adversely affect, they remain unaffected and fully applicable. And it is important that the AI Act on the one hand and these existing protections on the other hand reinforce each other. Now, I know that some, I mean, it's not a secret that the European Data Protection Board last year published their opinion on how they interpret this complementarity, meaning one should absorb the other. At BIPT, we think this is not the right direction to go. There's a need for collaboration between market surveillance authorities under the AI Act on the one hand, that are responsible for the product oversight, and on the other hand, sectoral bodies, domain-specific authorities like data protection authorities. And this has to be done with respect for the duty of sincere collaboration, which has been stressed by the Court of Justice in the German Meta case. So yes, second point, there is definitely a need for collaboration, but that doesn't imply that existing authorities or bodies necessarily need to be designated as market surveillance authorities, because we believe that this might create tensions, conflicts within these authorities, and secondly, that it might not necessarily lead to the most effective, or that it's rather the combination of MSAs under the AI Act and the existing authorities which can act under their current competences, that this will lead to a reinforced oversight. And it might also render procedural complexity lower, because if you put in place two MSAs competent for more or less the same aspects, this is an open call for parties to appeal before courts of appeal or whatever the competent appeal body is. My third point is we will have to live with some fragmentation, because the AI Act contains the seeds of fragmentation. For Annex 1, it puts forward as the default rule to designate the existing market surveillance authorities under product safety legislation. For the financial sector, the default rule is designate the existing financial supervisory authorities. I guess that shows somehow the lobby power of this sector. For Annex 3, certain areas of Annex 3, so migration, border control, law enforcement, justice, elections, plus biometrics in relation to that, Article 74, paragraph 8, points in the direction of either the data protection authorities or equally independent authorities. So there, member states need to designate an authority that is independent from both private and public sector. So is this a bad thing, this fragmentation? Not necessarily. The risk-based approach under the AI Act requires that you have good insight in sectors so that you would know what the impact of an AI system will be. So this sector-specific expertise is essential for supervision of the AI Act. And perhaps a one-size-fits-all is not appropriate for these various sectors. I guess the risks that the use of AI systems can bring in a sector toys might be different or of different nature than with medical devices. Although there are also examples to give where AI-driven toys can lead to serious harm. So we will have to live with a certain fragmentation, but therefore we need to keep things simple where we can, and not necessarily appoint anyone who is interested to take up a role in this AI regulation. And everyone is interested because AI is hot these days, so there's a huge interest in taking up a role. But let's keep things simple where possible. Designate MSAs where you have already authorities with that experience. Keep it as central as possible, but put in place collaboration mechanisms so that you can take on board existing sector domain-specific expertise where relevant. Thank you.
Thank you very much for this three introduction to the AI governance. And I would like to proceed with perhaps asking a few questions and perhaps beginning a discussion. Coming back to a common point that was first mentioned during the keynote, and Elisabeth and Peggy also pointed out, is the optimism that was drawn from the keynote on how regulation is actually a good thing and something we thrive at. And I was wondering, because in his report of last September, Mario Draghi actually had a fairly severe opinion on the regulatory landscape of the EU being an obstacle to innovation. And so it's nice to have a contrary view presented today. And may I ask what you would make of it, and how do you foresee the AI governance as it transpires from the AI Act at the moment perhaps will foster innovation in that sense? So if someone would like to...
May I just because you're telling this, what would be the different solution if not having a regulation on European level? The different solution would be having a 27 different regulations, because when looking at our continent, every single national bureaucracy will do everything to find solutions for themselves. Yes, they are talking. It's what Brussels is making is wrong. But nevertheless, everybody would have a fragment. We would have really a fragmented regulation on the national level, like the US will have. They will have it. Several states will take the European AI Act, like they did with the GDPR also, and take it with them and make the best out of it. What we can learn from the US at the end, regarding deregulations, that what they are taking out of our regulations, and then perhaps think, how can we make them smarter? How can we make them more flexible? That is also what, and that's perhaps one of the problems of the European regulation, that it lasts very long. So making an adaptation of the GDPR, making an adaptation of the AI Act would last too long. That's the problem. Perhaps we have to say, perhaps that can be done better, but nevertheless, having this legal framework, having a European-wide same approach on AI is very important at the end for investors and for innovation. So you will give your money rather to a country where you are sure that your investment is not at stage at any time. So I think looking at the US, I think we will see how successful they will be, but at the end they will have their regulation, even under this current administration.
I fully support that argument, and I would like to add a few more, one or two more. Don't forget that the AI systems covered by, the AI systems covered by the AI Act are what, 85, 90% of all the AI systems out there. So this is not about regulating any AI system that will be put on the market. No, it's about controlling those who present high risks and forbidding those applications that we do not want. Our European democratic societies, the prohibited practices. So that's an important thing to keep in mind. And secondly, Klaus mentioned harmonization, which will be beneficial for legal certainty. Another thing that will be beneficial for legal certainty, or to add to that argument that AI Act is beneficial to legal certainty, that is, AI systems were not unregulated until the AI Act was adopted. Consumer protection, data protection, non-discrimination laws, also administrative law was already in place and was leading authorities and courts to adopt decisions clarifying how AI systems had to behave or to be designed. So what the AI Act does is now put forward essential requirements for high-risk systems. Technical standardization process is taking place, and Sanelec is working hard on these technical standards. So in the end, the whole industry will know what to do if they want to put on the market high-risk systems, and for deployers if they want to use them. So what the AI Act does is to set out clear guardrails to provide legal certainty and a level playing field. Also very important. Treat everyone in the same way. Now, is this needed? In case someone was wondering if we really need these guardrails, I heard in Brussels earlier this week the testimonial of Mrs. Megan Garcia. She's from the US, but in Belgium we had a similar case, but she's from the US. She lost her 14-year-old son after engaging with a companion chatbot, claiming to be a therapist with all kinds of diplomas, engaging in discussions about self-harm, suicide, and unfortunately the kid committed suicide. And now she's advocating all around the world to put guardrails in place against high-risk AI systems and to take from the market prohibited AI systems. Because the only way that she had to find justice is to start a procedure before court, which will take her a lot of money, effort, because in the US, these laws are not in place. So this is what we're doing with the AI Act. Put up an enforcement mechanism that individual victims don't have to suffer in long court procedures. Public authorities, market surveillance authorities will be expected to intervene before harm can be done. Thank you.
I mean, it's a little bit hard for me to speak after you because it's very emotional. And I must say that I've never, for a long time, I've not been on the panel where I was so in agreement with all the panelists. I'm really surprised because usually it's, somewhere some speaking against GDPR and against these kind of things. And I can just say, I fully agree. And I want to add something from the experience with the GDPR we had in implementing the GDPR is a little bit that GDPR was adopted because of the fragmentation that you mentioned before, to have the power to be together. And what we saw also on ETBB level, that we are stronger together actually. And so when enforcing the GDPR also on, on most of the AI models that are usually not where they don't have like, an entity in the European Union, but are abroad, it's really like everybody would be coopted in its own of the authority. So what we did, we established a task force to be stronger together and to exchange, incorporate on the things. And with the GDPR also, I went on in 2019 and also later I went to the US, and we had great discussions with university, with professors at university, and also with stakeholders, and what they said that it's really, really difficult in the US. I mean, we'll make a lot of lawyers make a lot of money to interpret all the different legislation, but it's really sometimes really difficult. And at some point, with also the California, when you look at the California data protection law, it's really like some things are really like some almost copy paste from the GDPR. And also when you look in other areas on the globe, it was really like a little bit of I mean, I don't want to say gold standard because it's really Eurocentric approach to this kind of things. Nobody has to adopt a GDPR like legislation to protect to have data protection. I want to not go that too far, but what we saw is that they were really looking at Europe and looking at the law and try to adapt or get inspiration from the concept. And I think we were in Europe, we were, you know, stricter and averse to ourselves and doing like, oh, the GDPR is stopping everything. But what I want to say is, and you mentioned it before, and I like the sentence, if we can translate the whole thing, you said before in your presentation, and this is really important, and what we saw in the GDPR, will be really important. And I think the AI Act did a good approach because they, before the implementation and getting to force the AI Act, they established offices that are, you know, service offices like the RTR GmbH, who really provide guidance to the people who want to develop AI systems. And this was a little bit different with the GDPR because we also have this kind of thing. We have to give guidance, but we are also enforcing. So it's really difficult to not, you know, give guidance and then having like a real case and really enforcing and really investigating. So what we really have to do in making the AI Act, all the provisions in there a success, is that we have to translate it to make people aware what they can do and what they cannot do. And with the GDPR, there's a big awareness. But we see in our daily business when with the number of complaints lodged, and there is a big awareness, but also like the GDPR, the cookie banner is also like what we see on a regular basis. But it's really important just to also tell the people, and it does not only affect like the regular data subject or the regular people, it also affects like people that are in the companies and working in the companies, that they are affected by things, and it's a fundamental, at least data protection is a fundamental right. And it's really important for them because they can be affected too. And so I think we should, what is really important to have this public awareness to translate the thing, and to make the people aware of the obligations and the rights they have.
Thank you. I will take the opportunity to jump back on well, the GDPR and the Brussels effect that you mentioned, to ask. The GDPR was groundbreaking in its own way, and we thought this Brussels effect, even today, really being a source of inspiration worldwide. As you said, the California Consumer Protection Act also almost copy-pasted some aspects of it. And so my question would be, and if you don't mind, Elisabeth, to start answering on this, would be what kind of lesson learned do we have from the GDPR implementation, as much on a national level, but also by private actors, perhaps maybe anticipating a bit much on the AI Act also having this Brussels effect, and saying, because even though worldwide we see some regulation being adopted, but maybe not to the extent that we have in Europe, and how, having like kind of a lesson learned on this.
Thank you. I think most of the things I already mentioned when I talk about the translation and the public awareness. I mean, the first thing I wrote down is enough human resources in the authorities, and also in all the, I mean, that's my key sentence for the next a few months, that you have to have the people that are dealing with the stuff and can, you know, can provide, can enforce the thing. And I love the thing now, I must say. And yeah, and this is really crucial. And this was really, I think, something that really affected the enforcement of the GDPR, because throughout the years, when we make a report in EDPB, when you look at the EDPB is the European Data Protection Authority, Data Protection Board, where all the data protection authorities are part of and work together. And in EDPB reports, there, I think through every GDPR evaluation and also EDPB report, we raise the lack of resources. And so this, I mean, I can, you know, this is a letter to Santa Claus and to the Christkind in Austria, that we have to have people implementing the AI Act on the governmental level and also provide, and so provide information. Public awareness I raised, legal, and one message I will always say is that no decision is made on the second day of the when the AI Act is enforced. This takes time. Legal certainty will take time. The courts will take time. We will have to implement the things. I don't think that in many member states already the market surveillance authorities are really determined and designated. So we really have to build and also have to learn to be a market surveillance authority, and we and any other things. And I also agree, and I think it's really funny that you mentioned the toys, because we also always do this as an example, that we say that some things might be better with the data protection authorities, but some things might not, where we don't have the expertise on what is really necessary in this area. But to stay with the question is also what we saw, and what we do is support small, medium-sized businesses who have not the resources like a big entity, don't have like a legal department, compliance department with 20 lawyers or 20 technical experts that are implementing and having like drafting internal guidelines. So this is really something that in our view, in my view, is really important for the success. And public awareness, practical, and also a practical.
Thank you. You like Peggy or Klaus adds?
I could perhaps add a few things, although I have not enforced GDPR in the past. So, but I'm familiar with the criticism that has been voiced on the GDPR and the administrative burden and bureaucracy. You have to document a lot, that's true. And under AI Act, you will also have to document a lot. But this documentation shows that you've been properly reflecting on what you intend to put on the market or what you intend to deploy. So I guess that's a good thing. And indeed, smaller companies do not have a team in place, a compliance team. So is it then a solution to provide for an exception for SMEs under the AI Act that has been put forward as an idea? I heard Irina Orsic of the AI office earlier this week say, we don't think so. Because also, I mean, the risk that you might create with your system does not depend on the size of your company. So that's perhaps not the best solution. But what you can do, and that's an important point, I guess, both the GDPR and the AI Act are not only about enforcement, it's also about guidance of the sector. So indeed, authorities that will have responsibilities under the AI Act, it's important that they also pay a lot of attention to awareness and guidance of companies, deployers, especially the smaller ones. So enforcement and guidance of the sector should be two coins of the same medal. And perhaps the criticism voiced on the GDPR in the past was due to the fact that some authorities pay too much attention to enforcement only. So this is definitely, I guess, a lesson that we should draw from that.
Thank you.
Good. So we heard a lot about that, and as we are talking about governance, so it's often also Peggy said in her 3 points how the kind of working together should change. As I'm coming from the industry, so for a long time, and most time of my working time, I stayed in the industry till I changed to the regulation. I have a bit of different approach how future regulation and governance should be to make it successful, and how to help also to bring all these expertises together, because more than even the GDPR, the AI is much more cross-sectoral, because products can be in each sector. They can be it does not you cannot focus on a specific sector. So it's cross-sectoral, and that really demands I would say a new approach of governance. We should not stay in the silos. Peggy also mentioned that. And from my point of view, coming back to industry experience, future regulation must be something like a project. It's not like a project management. And I would say in a project, you have a sponsor, you have a lead, you have a steering board. So the sponsor is, I would say, the government or the European Union. They are the sponsors of this. All the lead that should be in each country one nominated authority. Well, the existing authorities one nominated, and you have a steering. That's all the other MSAs you see. And then what you really need when doing the work with the AI, doing real work in favor of industry, in favor of customers, in favor of economy at all, you must really make the 150% is you should have a plan, you should have tasks and responsibilities, and you should have a clear review system. That's 50% of the work done. That must be very transparent. And the other thing is 50% is communication. That's what Elisabeth also said. So really, that also one of the learnings out of the GDPR. That was the wrong communication. And even when the AI Act came into force, there was and you know it from the media. Everything you see at the first time when somebody is talking about AI Act is one of the robots. Maybe it's a nice robot, or the other side it's an angry, bad technical thing. You're scared. So therefore, that's the communication we have already. On the other hand, I always say the main discussions on, and that was perhaps a no learning of the GDPR. The main discussions about AI at the beginning, especially when the AI came into force, was about Article 99 and the penalties. So everybody was talking about the penalty, and at the end it was where every small company who thought about using AI had then the fear that they have to pay 35 million euros for using any AI. So that was the beginning. Now it's changing, and that's what's very important, that we as authorities and also academia is really asked to support it. We have to really find a communication system. We have to show the chances, but also discuss about the risks. But discuss about the risks at the rational level and not about emotional level. So I think that's important. That's for future authorities what they have to do, just to bring it, to make it transparent, to bring it on a very, I want to say low level, but in a very easy, smart way towards the people. That what we are also trying. That was also the reason why we talked about this service desk at RTR. Just even before there was an AI Act in place, because we were convinced it's necessary that people get aware of that and can take a look and can see, hey, that's not so difficult or so dangerous as seen or as I've read in the media, because I think that's the best thing. And therefore, it's really necessary also for us as authorities just to have a bit more this project management approach. It's a project for us. We don't know what will be the outcome at the end. We don't know many things ex ante. So we have really to try to learn, to make mistakes, and to then realize. That means just in this case, working together, coordinating and using the expertise of the others. So if perhaps RTI is one of this coordinating authority, they will necessarily use the knowledge and expertise of the data protection authority regarding data protection. So it's on the other hand, we can offer market surveillance authorities or a data protection authority more the economical and technical background, which we already have. So that's this kind. So it's this project approach for me is the right government approach, and I can say Elisabeth also knows it for the Austrian regulatory authority also already started just to have a network established where we meet, where we talk, where we give and exchange our knowledge and try really in the digital era to use our knowledges, not coming to the conclusion that you need an additional new one AI authority doing all the cross-sectoral things. So that's, from I think, the future work when we are able as authorities just to support this and have the government who really gives us these tools and helps us just to bring that forward in a new way, makes us, I say, fit for project management tools, then we have a good chance really to do a good work and bring it forward also to all the people and make it successful also in competition.
Thank you. Something, of course. What is we're all in agreement all the time, I think, today. But what was mentioned is that I think a crucial point when there are more than one market surveillance authority appointed is the cooperation and the coordination for legal certainty. Because if everybody is, in Austria, you say doing their own in your own pond, being in your own soup and having your own soup and being in your own pond, there will be not legal certainty for certain things that affect us all when implementing and when enforcing and when being market surveillance authority. So coordination and cooperation is also key. And I hope there will be enough, and also the legal framework for that we can exchange information. I mean, there are certain and many institutions in the AI Act already setting up on European level and also on national level, but that we are working together, and there's also many already, and I can assure you that there are many exchanges already between authorities that will be probably have competence and working groups established. And for the network, I also want to add that it's also important we rotate our staff. There are sometimes exchanges of our staff, the people from the and we're really happy about the RTI is really always really welcoming, and we're so happy that our staff is working a month with, for example, with people from the authority at the RTI and vice versa, that we exchange our experience and also to better understand what the other ones are doing, because we were of course, focused on our GDPR and our national data protection law, and we really have to, look over our pond. Hope that's the right formulation. And then thank you. Sorry.
Thank you. I will quickly ask the last question to wrap it up, and then to sort of our audience Q&A. My last question would be, and I'm really taking advantage having regulatory members here and also from 2 different nationalities. That's very nice, and I'm really going for it. Since I have a French legal background, as you can imagine, I'm looking at what is how the AI Act would be applied, implemented in France. And I know that our French Data Protection Authority, the CNIL, is kind of trying to grasp it. There are discussions at the moment on whether it would be CNIL or ARCOM, which is the media authority at the moment. Therefore, I was wondering, because Peggy, you already sort of started answering this question by saying that it perhaps should be a new authority that should be created to avoid okay, maybe I got it wrong. I thought to avoid tensions between existing authorities, or there was something to that extent. How would, if one existing authority, so let's say a data protection authority, would take on being the AI authority, how would it work also like in terms of interpretation and guidance as well on cooperation between those different actors in like 3 minutes?
I also understand, Peggy, in the way that one of the existing authorities should overtake no new authorities like you.
Not a new
Not the
authority.
new one, so just
So
taking
ideally an authority with experience in market
Experience.
surveillance who acts as central authority and then collaborates with the sectoral
as we-
domain
but
specific.
therefore,
Yeah.
just that fits. I'm also convinced that this is the best way. The question is, that's also a decision the government has to decide. What would I want to achieve with the regulation? Yeah? If it's, and when we are talking about regulation, we are all often mixing up different kinds of regulation. One thing is more the enforcement part. That's data protection authorities are more on the enforcement parts. Competition authorities are more on the enforcement part. On the other hand, you have this typical sectoral regulatory authorities, like it was the telecom regulators, like it was where the energy regulators. They're more on the sector. They are more. Their demand is not so much making the enforcement and bringing fines if somebody is doing something against law. Their approach is more, they have to develop markets. And what my mindset and what I always thought is, the AI there's a real big chance for future industry, for future economic development. So therefore, we don't know what everything what will happen, but we should use these tools for future economic growth. And so therefore, we have to develop markets. We don't know now. We know now what we have, that there's this technology. We have an idea where it could lead. And we see, okay, here the risk, it could go completely in the wrong way, which we don't want, but it could also be really a good thing for the future, for economy, what we want. So therefore, there should be an authority who has in mind, we should develop markets. So therefore, I'm convinced it does make sense if this coordinated role, if this more developing approach is be done by an authority who has experience even in this part, but nevertheless, you need also a corresponding enforcement authority. And here is the part how this coordination, cooperation should happen. But on the focus, I don't know how you see it. Personally, I think AI is a chance. It has many possibilities. It will bring the economy on the next level. It's really one of these revolutions we have to face. We have to do the best with. We have to use that, and based on this, it's good really to try to. I would say, okay, you have this sidelines you have on the street. Here's the street we want to go. We know we want to go there, and there should be on the left and on the right there should be a guardrail at the end. That's what I wanted to say, and that's my understanding of regulation this way. Thank you.
Thank you. I will ask Elisabeth and Peggy very, very briefly so we can switch to the Q&A.
Please go ahead.
I just want to say that I agree that has similar aspects, but is also different to an enforcement. I mean, there are many tasks we have, and some are similar that we already have, that we like accreditation, certification, code of, we investigate investigate, not like we look at code of conduct and then we adopt code of conduct. And there are similar things, but it's still a little bit different to be a market surveillance authority than to be like a data protection enforcement authority. And I agree that we should, of course, in certain fields, with where there are high risk systems and personal data mainly involved because of the kind and the purpose of the system, it might be clever to use the the Data Protection Authority, but in other fields, it's maybe more cleverer, I don't know, to use another authority for market surveillance that had experience. And so I repeat your stance that you made before. And I think there are really interesting and important discussions already taking place in Austria according to that. But I think we have to be aware that the task is quite different or similar in some ways, but is still different to what we are doing right now with the GDPR.
Okay, so I will try to clarify the model that at BIPT we would think is the ideal model. So if you have a central authority, a central market surveillance authority, to the extent possible, because the AI Act points to others, some authorities in some cases, but to the extent you can centralize, if you have a central MSA, the task of that MSA is, in the case of high-risk systems, check whether it's in conformity with the requirements. If that's not the case, you take it out of the market for the whole of Europe. And in that sense, this is different from, I think, the traditional GDPR regulation, where you regulate for your own territory. So
usually, but we have like
you have your collaboration with the EDPB. I'm aware of that, but if you take a national decision, it's applicable to the.
I mean, we look over like the country, the border a little bit because of course, and we exchange on that. Sorry.
Of course, I'm not saying you're exchanging. I'm just the effect is different of a decision. So, as a market surveillance authority in radio equipment, if you see a mobile phone is not in conformity, you take it out of the market, it's put in a database, MSAs from other countries can react within a certain period. If they react and say it is in conformity, we don't agree, the commission needs to decide. So this is how market surveillance in product safety works. Of course, with the AI systems and all the other dimensions that come to the fore in the AI Act, the prohibited practices, transparency requirements, the MSA needs input from sectoral bodies or data protection authorities to make a judgment in certain cases. Is this a high-risk system or not? Is it sufficiently in compliance with this or that requirement? So that's where I see the collaboration. So the input from the sectoral bodies. And I think that's also the model that in the Netherlands, they try to set up this combination of product safety on the one hand, sectoral oversight on the other hand. In Belgium, as we interpret the new government agreement, because since the beginning of this month, we have a new government also at the federal level. And in their government agreement, it stated explicitly that for the oversight and the coordination of the AI Act, BIPT will be designated. So we interpret that as the wish of the new Belgian government, but talks are ongoing, to put in place a model that is as central as possible. So that's because you were wondering what's happening in member states. Well, that's the state of affairs in Belgium for the moment.
Thank you very much. And thank you very much for this very interesting conversation. I will now ask whether there are some questions in the audience before switching to coffee and cake. Just for people online, the live stream will stop for the duration of the Q&A, and the second panel will start at 3:45. Thank you.
First, we will start with a keynote, and afterwards we have the panel discussion. The keynote is by Elora Fernandez, and she's a postdoctoral researcher at the Leuven Center for IT and IP Law, where she focuses on children's rights in the online environment. She defended her joint PhD in law at both the State University of Rio de Janeiro in Brazil and KU Leuven on children's data protection in educational technologies. Previously, she worked with NGOs specializing in digital rights across different countries and served as a trainee and interim legal officer at the European Data Protection Supervisor. I'm really happy to give the floor now to our keynote speaker, and I hope you can hear us.
Yes, I can. Can you hear me?
Yes, we can hear you. Thank you.
Perfect. Thank you so much. Good afternoon, everyone. Thank you for the invitation. It's really a pleasure and an honor to be here with you today to talk about AI literacy in such a special panel. Thank you, Adriana, for moderating this, and also for the editors of the book for the invitation. So my goal for today is actually to briefly provide you with an overview of the main requirements related to AI literacy in the AI Act. So then you can go a bit deeper in the discussions within the panel. If I can change the slides. Yeah. So before I go into the specific requirements, I would like to briefly discuss what was the legislative path of the obligations in the AI Act. So the obligations that we have there related to AI literacy actually comes from the version that we had from the Parliament in May 2023. The Parliament proposed a new provision on AI literacy, and it was especially focused on member states regarding the promotion of measures to develop a sufficient level of AI literacy across sectors. So it would be for everyone in the society, regardless if they were or not affected by any specific AI system, as well as for providers and deployers of AI systems. But the outcome, as we know, is that the provision that is integrated in the AI Act so far as now is actually narrower in scope because it only focuses on the providers and deployers of AI systems. And of course, and probably that's why we are here today discussing the specific provisions, it was part of the first batch of provisions that came into force on February the 2nd, 2025. But what is AI literacy in the first place? We have a definition of AI literacy under the AI Act in Article 356, and it says that AI literacy means skills, knowledge, and understanding that allow providers, deployers, and affected persons, taking into account the respective rights and obligations in the context of this regulation, to make an informed deployment of AI systems, as well as to gain awareness about the opportunities and risks of AI and possible harm it can cause. So it's kind of complex, so I would like to go into detail in each of those highlighted parts and focusing specifically now on the skills, knowledge, and understanding. And for that, in order to understand what are skills, what are knowledge and understanding, and especially how they are different from each other, I think it really helps if we look at Bloom's taxonomy of educational objectives. So this is a taxonomy that is widely used in pedagogy to establish the goals of education, so people can actually develop certain competencies. And here we can adapt this actually to AI literacy and align this with the wording of the definition that we have in Article 3. So as you can see, know about AI is a very basic, a very passive way of approaching it, according to this taxonomy, of course. So it's about recalling and recognizing certain facts. So people can actually copy, reproduce, recall, and memorize AI concepts. So then we have another layer, which is actually understanding AI systems. So you can explain certain ideas or concepts, you can actually interpret things. And then I would say that for the top 4 layers, we can talk about the skills that is there in the provision, because you would necessarily demand, really requires direct practice with AI systems. And that is why I would personally include those in this idea of skills. So for example, when you want to apply the knowledge and the understanding that you have acquired so far, you can actually use this information in new situations. You can execute, implement, use, and apply AI applications in different contexts. You can also analyze what you've learned so far to draw connections among ideas, organizing, comparing, decomposing, and also abstracting an AI problem. Then the next level, according to this taxonomy, will actually be to evaluate. And here it's really important when we're talking, for example, about ethics, evaluating AI in terms of ethics, in terms of lawfulness, because you have to justify a stand or a decision. So the person in this level is able to appraise, to predict, to detect, and to justify decisions with AI applications. And finally, there is this level of creating, to producing new or original work, for example, designing, assembling, constructing, building, or developing AI applications. So here, the top 4 levels, they're really important because we're really talking about this critical aspects of AI, of actually being able to question the outputs of AI, to really advocating for the ethical and lawful use of AI systems. It's also important to note that AI literacy is multifaceted. So we're not only talking about the knowledge, understanding, and skills related to the technical aspects of AI, but also, and very importantly, the ethical and legal aspects of well. So it's multifaceted and also interdisciplinary. And also a very important disclaimer here is that this taxonomy, as it was developed in the 50s, is somehow seen as hierarchical. And this is not something that we really want for AI literacy. As we'll see in a bit, it all depends on the person, on their role, on their rights and obligations in relation to the AI system. So what you need to know, what you need to understand, or what you need to be skilled on will really depend, will vary necessarily from person to person and from system to system. So it shouldn't be something hierarchical, because it will depend on the specific context that you are applying this. But it helps us to understand a bit more what are the levels that a person can get in terms of AI literacy, I would say. Recital 20 also helps us a lot when we want some examples of those notions. So notions here is actually, again, the understanding, knowledge, and skills that we were talking about previously. Of course, it says that it will vary with regard to the relevant context, but it gives us some examples, such as understanding the correct application of technical elements during the AI system's development phase, also the measures to be applied during its use, the suitable ways in which to interpret AI systems' output, and in the case of affected persons, the knowledge necessary to understand how decisions taken within the assistance of AI will have an impact on them. So apart from understanding what is exactly the skills, the knowledge and understanding, and how they differentiate from each other, we also need to understand what are the objectives of AI literacy. Because, okay, so what do you want this knowledge for? And the provision also gives us a hint. It says that we need those notions to make an informed deployment of AI systems, as well as to gain awareness about the opportunities and risks of AI and possible harm it can cause. And we can go to another level, a little bit deeper, if we look at recital 20, for example, because there we can see, okay, why do we need to make an informed decision in such cases? Why do we need this kind of awareness? Because first, we want to obtain the greatest benefits from AI systems while also protecting fundamental rights, health, and safety. You also want to enable democratic control, to provide our relevant actors in the AI value chain with the insights required to ensure the appropriate compliance and its correct enforcement. And this is really important because, of course, to the most basic level, if the person wants to be compliant with the AI Act, they need to know exactly, for example, in which tier of risk they are included. So AI literacy is really important beforehand to be compliant with the legislation. It also contributes to improving working conditions and also sustain the consolidation and innovation path of trustworthy AI in the Union. Another important point here is also that to make an informed deployment of AI systems is really, really key when we're talking about human oversight. And this is something that Recital 91 also reminds us of. So it says that deployers should ensure that the persons assigned to implement the instructions for use and human oversight, as set out in this regulation, have the necessary competence, in particular an adequate level of AI literacy, training, and authority to properly fulfill those tasks. So very important for human oversight. We're going to go back to this later as well. So now going a little bit deeper on the provisions, specifically in Article 4. It's also very compounded, so we're going to focus on those highlighted parts. Before a brief overview, it says that providers and deployers of AI systems shall take measures to ensure to the best extent a sufficient level of AI literacy of their staff and other persons dealing with the operation and use of AI systems on their behalf, taking into account their technical knowledge, their experience, their education and training, and the context of AI systems are to be used in. And finally, also considering the people that are going to be affected by these AI systems. So first of all, who bears the obligation? Again, the final version only focuses on the providers and the deployers of AI systems. And here we're talking about all AI systems, so applicable to all systems, regardless of the risk tier or whether they include a GPIA model. Of course, if we're only talking about the model, it wouldn't be applicable to them. But if we're talking about the system in general, even if it includes a GPIA model, it will be covered by this obligation. And to whom? So who actually need to develop those skills, knowledge, and understanding? We're talking about the staff, mainly, and other persons dealing with the operation and use of AI systems on their behalf. So here, it can also include, for example, individuals in the company that only interact only occasionally with the system, as well as external consultants, temporary contractors, third-party vendors, etc. A question that we had that I also discussed with the co-authors when we were writing the commentary on the AI Act Article 4 for the book was actually, okay, but does that include clients or end users? And our initial understanding was that no, because first of all, they would not necessarily be dealing with the operation on behalf of the providers and deployers of AI systems. And also because of the legislative path, we have removed those broader obligations from the member states. So our initial idea was that, okay, it wouldn't include clients and users, but actually, I was also watching the latest webinar that was broad streamed by the AI office, and their understanding, the understanding of the commission, as far as I could understand, was actually that it includes. So it would include clients, it would include end users. So we would have this more protective interpretation of this obligation according to them. And this is also aligned if we see with the definition of AI literacy in Article 356, because they're not only talking about obligations, but also taking into account the respective rights of the people as well that are affected by such AI systems. And okay, so we know to whom it is applicable. So now what is the content of this obligation? So here we're talking about measures, so something really broad, measures to ensure to the best extent a sufficient level of AI literacy. So a lot of open-ended words here, taking into account a lot of things. So technical knowledge, experience, education, etc. We're going to go into detail in each of these parts. So first of all, we need to understand that, of course, as we've seen in the taxonomy, we need to talk about levels of AI literacy, because, of course, the person who is there developing the AI system in itself won't necessarily have the same understanding, the same skills, the same knowledge as, you know, a child of 12 in their school using an AI system there. So it will necessarily vary from person to person, from system to system, from sector to sector. So we need to talk about levels of AI literacy. And Article 4 talks about a sufficient level of AI literacy, which basically means the minimal requirements, the minimal threshold to achieve the objectives that we have discussed before, the objectives that are set out in the specific provision and also Recital 20. When we're talking about human oversight, Recital 91 talks about adequate level, which is basically the level that is necessary to properly fulfill human oversight activities. And here, of course, we're necessarily talking about higher levels of AI literacy, because it's really the person there overseeing all the activities. So it's probably the person who needs to know the most about this specific system and how it works. And finally, and this is also something that we have discussed in the commentary, AI literacy needs to be appropriate to the person that is receiving the training or being affected by other measures that we'll discuss. It has to be adapted, personalized to the specific individual in the operation of the system, considering a lot of things that we'll discuss right now, because this will impact the measures to be taken. Okay, so what the measures should take into account? First of all, as I said, the individual's technical knowledge, their experience, their education, and training. So especially when we're talking about training, we'll see that measures are not only training, but especially when we're talking about training, this will probably mean that you have to have tiers of training depending on what the person's background is, where they work in specific in the company, or how they are, what are the responsibilities that they have in relation to the system. Which brings me to the second point, which is the responsibility of the person itself. For example, if the person is overseeing the system, or if it's a manager taking decisions based on what the system is providing them in terms of information. So they also need higher levels of AI literacy. It also should also consider the context the AI systems are to be used in. So the sector it is applied to, if it's something really strategic, for example, as health, as education, or here, for example, the risk it poses to end users. So of course, as we mentioned, the risk tiers here are not necessarily important for the application of the provision itself, that it's applicable or not. But of course, it will impact how you apply this provision in your specific organization. And finally, the persons or groups of persons on whom the AI systems are to be used. So if we're talking about children, if we're talking about migrants, if we're talking about employees, for example, you probably need to establish specific measures to deal with their specificities. We've talked, for example, in the first panel about the necessity of aligning the AI Act with other legislation. So a person, for example, dealing with migrants will necessarily need to know more about non-discrimination, for example. So it needs to take into account the specific people on whom the AI systems are to be used. And also these measures should be implemented to their best extent. So of course, it's always a balanced approach. You need to make reasonable and proportional efforts that will balance the risks that are posed by the AI system with the measures that are implemented. Okay, so we've talked about what it should take into account, but what really are those measures? What are some examples that we can mention here? The difficult answer is that there's no one-size-fits-all solution. Measures will be always highly context depending, which is good because it also provides us with this flexibility of implementing measures, of adapting it according to the specific context. But I think the most important thing here is that, and this you've probably all seen in the latest months, how the possibilities of training are getting more popular. A lot of companies, for example, providing training in relation to AI literacy to other companies. But it's not only that. It really requires a holistic approach. So it should include measures that also support the development of the skills, knowledge, and understanding, considering the limits of human cognition, of course, and also the technology state of the art. So just a few examples of things that we could consider apart from training, apart from this first bullet point here, which is ongoing opportunities for learning and acquiring skills. We could, for example, talk about improving the technology design itself. So improving auditability, transparency, explainability, the criteria for providing input and assessing the output quality. This will all, of course, affect how people understand AI, how their knowledge and skills are built. Assessing the technology governance. So we just talked about AI governance and the allocation of responsibilities of the decision chain. So who is taking the decisions in relation to the outputs that the AI, for example, is providing? It will necessarily affect how the person in specific should be trained, or the measures in specific that should be implemented. Assessing and mitigating risks across the AI lifecycle, so compliance with AI and other legislation. We've also talked here about this before. Regular monitoring is really important, so this should not be something that you do once and that's it. It's also included in recital 20. It's related to these appropriate follow-up actions that are mentioned there. the importance of stakeholder involvement. For example, if we're talking about children have the right to be heard in the Convention on the Rights of the Child. So as much as possible, they should also be involved there in these measures so we can adapt the AI system to their best interests. The right to explanation here is really important. So if we're talking about, for example, measures related to AI literacy for clients or for end users, and they want to explore the right to explanation, then it should also be taken into consideration their levels of AI literacy and how you can provide this explanation according to it. And of course, documentation, I think it was Professor Peggy who mentioned this as well, is really, really important of any effort, including, for example, participating in such events, online webinars, whatever. I think most of organizations are already doing a lot, but of course, if you don't document it, it doesn't exist. So document everything, any effort is really important, so you can prove afterwards that you have actually implemented all these measures that are necessary. And if you want to have a look on different examples, the Commission has issued this Leuven repository of AI literacy practices, which is really interesting on the organizations that are part of the AI Pact. And there you have a lot of options. I would say that the majority of them are still focused on training in specific, but of course, this is the first version. So I hope that we have more interesting things in the future as well. And the question that everybody asks is, okay, is it enforceable? Because AI literacy requirements are not directly linked to fines. As we just mentioned, market surveillance authorities will not necessarily be in place until August 2025. Most of the regulation is still not applicable. So, okay, will I receive any fines if I don't really comply with Article 4? It's really important to note here that authorities will have a lot of room for maneuver when they're deciding whether to impose a fine and its amount or any other kind of enforcement activities. So AI literacy obligations could be and probably will be considered indirectly. So Article 99.7 states that authorities must consider all relevant circumstances. And here, just two very brief examples that could, for example, include AI literacy are the degree of responsibility of the operator, taking into account the technical and organizational measures implemented by it, and also any action taken by the operator to mitigate the harm suffered by the affected persons. And it's really, really important, as we mentioned before, when interpreting the provisions on human oversight and also the transparency requirements. So it will probably be considered indirectly when assessing the compliance of the organization in relation to the AI Act in general. We expect further guidelines from the Commission on AI literacy, so we hope that this is out soon. Recital 20 also mentions that the European Artificial Intelligence Board should support the Commission to promote AI literacy tools, public awareness, and understanding of the benefits, risks, safeguards, rights, and obligations in relation to the use of AI systems. And also in cooperation with relevant stakeholders, the Commission and member states should facilitate the drawing up of voluntary codes of conduct to advance AI literacy amongst persons dealing with the development, operation, and use of AI. As I mentioned before, we had already a webinar, a third webinar on the AI Pact that was really focused on AI literacy and the specific provisions. We have the Leuven repository of AI literacy practices. And of course, let's not forget about the two guidelines that are already out there. First on the definition of AI system and also on the prohibited AI practices, because these are going to be really important, especially for the people that are really dealing more with the legal side of AI. And there they specific mention in both documents, for example, the need to align the AI Act with other regulation, the need to take into consideration this JU jurisprudence. So of course, all the new guidelines will necessarily be included in what you need to know in relation to AI systems in general. And this will be part of your artificial intelligence literacy portfolio as well. So to be seen what are going to be the next ones. And we hope to have future guidelines on AI literacy coming from the Commission as well. And here I'll leave you with some extra resources. Of course, the commentary that we wrote on AI literacy, Article 4. Also some blog posts that I wrote with some colleagues at CITIB. And also let's keep an eye on the authorities that will now probably publish a lot on the topic. So, for example, the Data Protection Authority from the Netherlands just issued a document on getting started with AI literacy. We just we know, for example, that the English version was out last week, if I'm not mistaken. So we're probably going to get a lot of extra resources in the next months as well. So I leave it here, and I thank you so much for having me here, and I'm really looking forward to all your views on the panel. Thank you.
Thank you so much for the great keynote and setting the scene, and also for being here with us today. My name is Adriana Winkelmann. I'm from the Department of Innovation and Digitalisation in Law, and I'm really happy to introduce today's panel here. So first we have Ceyhun Pehilvan. He's a counsel and head of technology, media, telecommunications, and intellectual property practice group at Linklaters in Spain. Additionally, he serves as a professor of law at IA Law School, where he teaches data protection, cybersecurity, and AI across undergrads, masters, and executive education levels. He's also founding editor-in-chief of the Global Privacy Law Review, a peer-reviewed legal journal published by Wolters Kluwer, and he's also one of the editors of today's named AI Act commentary, and also the AI governance and liability in Europe. Next to him, we have sitting Dr. Jeanette Gorzala. She's an attorney specializing in business law and artificial intelligence with over 15 years of experience. She advises clients on AI Act compliance and ethical implementation of AI systems, including generative AI. As an AI literacy coach, she supports organizations in developing AI literacy and governance frameworks. Actively involved in the Austrian and European AI ecosystem, she serves as a deputy chairperson of the AI Advisory Board of the Austrian government, chief policy officer of AI Austria, and former vice president of the European AI Forum, which is Europe's largest AI industry body. On my left side, I'm happy to introduce Dr. Lukas Feiler. He's a partner at Baker McKenzie in Vienna, where he heads the data, cyber, and AI practice. He holds a fellowship at the Stanford Vienna Transatlantic Technology Law Forum, and he has teaching positions for artificial intelligence law and European and international privacy law at the University of Vienna Law School. He's the co-author of multiple books on the GDPR, on cybersecurity, and most recently also on the AI Act. In his prior career, he worked as a software engineer and system administrator, and holds certifications as a system security certified practitioner, as well as certified information privacy professional Europe. On the left, we have also Sonja Dürrager. She is partner at BVP Hügel Rechtsanwälte GmbH, Vienna and Salzburg. She's head of the IT, IP, and data protection team. Sonja advises clients of all industries and sectors, but with a special focus on the technology sector, and also talks with it's advising companies in the development of software and AI tools. Thank you, all of you, for being here. Bringing from the keynote also a question, I would like to ask you a set of two questions, and we would also start in the same order than I introduced you. So the first question, I would be interested today, would be what constitutes an appropriate level of AI literacy, according also to your experience, and also how are companies and organizations are approaching this obligation, and what specific actions are they already taking, and what needs to be done. Also, if there are already existing best practices, and if there are already adequate tools, or do we need more?
Thank you very much, Adriana. Well, first of all, thank you very much to everyone for coming. It's been a great event so far, great panel earlier. So it's a great pleasure to be here. So in relation to the, and I also hope, by the way, that our multi-author book is going to contribute to the AI literacy as well. So that's also one of the goals. But in addition to that, so perhaps starting with a bit the background of Article 4. It was not included in the Commission's first draft, first proposal. So it was introduced more or less, I believe it was May or in the European Parliament's June version in 2023. And there was not, so it's an explicit requirement, I mean. There was a couple of implicit comments in the Commission's draft, but very, very vague references. And afterwards, so if you look at the Parliament's version, it was based on the opinion prepared by the Committee of Education and Culture. It was a much longer article. So, and it included additional requirements, especially for the member states. It also included a number of definitions. Perhaps as a result of miracle, after 6 months of trialogues between June 23 and December 23, we ended up with a much shortened article, which is now 3 or 4 lines, and it by erasing some of the obligations imposed on the public administration and as well as by member states. Interestingly, it also, so in the final version, the 2 definitions, they have also been deleted, but interestingly, we kept the same language in the article. In the article. So now we don't have the definitions, but we are using exactly the same words that were proposed in the June versions, and this doesn't also help much, in my view, in order to clarify and to provide legal certainty around these topics. That's perhaps one thing. Second, I think, and also many scholars have also criticized a bit the opaqueness of some of the trialogues. We don't really have much information in relation to the reasons why Article 4 has been eventually much shortened. Some argue that there has been a lot of lobbying. Some others argue that the aim was also to reduce the burden on the public administration and as well as member states. So there are a number of arguments, but because the trialogues, they were not that clear, we didn't really know what was being discussed. While most of the updates I have received, it was from the Euroactive newspaper from Luca, and I cannot remember his family name, but I'm sure you recognize him. Yes. So most of the updates that I was personally receiving was from his news, rather than the documents published by the European Parliament and other co-legislators. So we don't really understand why. What was that? What was the main reason? So this is perhaps the second comment. So now, in order to answer to your question in this context, Adriana, so what is really exactly what the adequate or sufficient level means? So this was, by the way, one of the definitions that has been deleted in the adopted version. So I believe that this is a bit unfortunate because we lost a bit the baseline. To answer to your question. So I think if we had that definition, it could have helped. In my view, this was a kind of a baseline that we could use. So in this context, also to answer to your second question that you have mentioned, how companies and organizations are dealing with this. So I can say from my perspective that I am advising several, well, as we have quite practitioners table panel, but I'm advising several multinationals in relation to the AI Act compliance. And so they have been so far adopting a quite proactive approach in relation to to providing training to employees and raising awareness across the organization, and we can discuss a bit more in detail in a bit what type of what specific trainings are being provided and so on. But I think the idea is not to give just another additional internal learning webinar of 20 minutes that employees, they will just click through without really understanding. But the idea is really go beyond that, just tick the box requirement, but rather I think provoking this internal knowledge and awareness. And this is not only for compliance purposes, but it is also actually several, and if Elora showed earlier a document from the AI Pact, many of the companies that are part of the AI Pact, and many of them, they have answered to the survey, which is published, and they mentioned, many of them, they published that as a result of this awareness, they were able to offer new services and products to their customers. So I think it is really key to see this obligation not only, oh, it is yet another burden, but rather from a more proactive and optimistic standpoint, and to see that actually this awareness can lead to real innovation in the company, because not everyone is skilled and has the understanding and knowledge of this concept. So I think this is at least this how I approach this this article, by being also enabling organizations to harness a little more of the of what AI can hide from them. So
thank you very much. Thank you very much.
It's a great pleasure to be here. Thank you for spending the afternoon with us talking about the AI Act and AI literacy. I would like to approach this topic from a very practical perspective, because we hear there is no authority in place, and even if there will be one, AI literacy will only be considered indirectly. So why should an organization actually invest a lot of resources in the literacy topic? And the answer is very simple. It's very important for AI adoption. The newest Future of Skill report underlines that about 70% of leadership identified lack in digital competences, AI and media competences, as a substantial barrier to technology adoption and digital transformation. So it's not important only because it is now a legal obligation. It's actually very core to the businesses to stay competitive. How we look at the AI literacy obligation, we already heard with only 4 lines. And I think one of the important findings is there is no one-size-fits-all approach to this. And I think this is very good and very adequate, because organizations are all different. How we look to implement this in the practice is we look at the role of the company. So are you developing your own in-house AI solutions? Of course, the bar is higher. Are you only using third-party tools, so you're only a deployer under the AI Act? Of course, the bar might be lower depending on which kind of systems you're using. So look at your role, look at the systems you're using, look at the risk footprint of those systems, because we know the AI Act follows this risk pyramid. Of course, you will not be targeting prohibited AI applications, but maybe you have some high-risk AI systems. If you don't, you might have transparency obligations. And after identifying the AI readiness level of your organization, your position, and also kind of like the systems you have, looking how to implement this AI literacy concept. And we've seen this repository. So also here, you can use a variety of different tools. I think the most important focus is to shape the awareness for this technology. So are you using AI? Are you not using AI? How does this technology work? Shape the skills in a broader sense. So not kind of like only clicking the box, as you very nicely alluded to, but also training the practical skills, how to use this, how to work with the output, how to question the output, and putting this in some organizational framework, because you will need some processes, governance, and roles for that. Regular training, different levels of training for different people, and looking at this from a continuous perspective, because this is a very, very dynamic field. Every week, so many new models are released. So much is invested in pushing this technology and scaling and further developing this technology. So you really need to stay on your toes and revisit this topic continuously as long as you're using AI in your organization. And the use of AI is getting more and more. We've seen in the most recent study, the AI adoption level actually, let's call it, surged from average 8% to 15% comparing 2023 to 2024. But that's almost doubling in 1 year. So we see there's massive speed here. And having the topic of AI literacy on the leadership agenda and really ensuring the buy-in of the employees in the company is key to build trust, to work with fears, and to remove barriers for successful and safe AI adoption.
Thank you very much for both of your insights. It's super interesting. You would be the next.
I want to take a bit of a very practical view on this. And that is, first of describing a bit of how many of our global multinational clients are trying to tackle that problem. And that is, I think, very much reflecting the purpose of the AI Act as a compliance problem. Very much looking at this from a risk-based perspective. So what are the risks we're facing if we're using AI? Let's find a compliance solution to this that scales for all of our many thousands of our employees, more or less globally, because AI regulation is not just something that's happening in Europe, but happening around the globe. So we need a global compliance solution that scales. So that basically means we're rolling out some kind of training, we're rolling out some kind of awareness raising measures, and basically treating this as a compliance exercise. And I think therein lies the fundamental challenge, and in particular for the European industry, the fundamental challenge. If we stop there, we stop short of what we actually have to accomplish. Article 4 mentions, in addition to the risks, the opportunities. But that is about the only provision that does in the entire AI Act. And accordingly, companies are very much focused on that risk. And what we are certainly seeing is that the larger the organization, certainly this applies particularly to industries that are a bit further removed from developing technology in-house, but still, as a general statement, I think it's unfortunately true. The larger the organization, the slower the progress. Any large organization at the end of the day moves like a super tanker. Once it moves, it does, but it moves slowly. So what we are seeing in many respects is AI being deployed, obviously accompanied by necessary compliance trainings, but deployed in a way that the AI transformation does only half of that term. It does AI, but not the transformation bit. My kind of favorite example is how Microsoft Copilot is being used in many organizations these days. People have Copilot draft an email, then they send it to a customer. On the customer side, there's also Copilot deployed, summarizing that email. So it's effectively Gen AI systems talking to each other. We're not transforming the process of, let's say, scheduling a meeting, but rather we have AI generate an email to propose time slots, and on the other hand, Gen AI reading that email. That is not living up to ultimately what we need to accomplish, way beyond the compliance minimum of what Article 4 requires us to do. And that I think in some respects, some industries are doing significantly better. And I want to say it is because they have to, because they are seeing something on a horizon that other industries aren't yet seeing. And that is the upcoming disruption that AI will bring in many industries. If I'm working in an industry where I know that within the next, well, maximum 2 to 3 years, we will experience a significant disruption, not just a slight adjustment of how we do things, but a disruption of the industry. The amount of AI literacy I will need in my organization in order to survive that disruption and ideally profit from that disruption. And professional service firms, I think, are very much included in that category. And we're advising a number of global professional service firms on how to tackle that challenge. And obviously, as a global law firm, doing our very best to tackle it ourselves. If I know that the way I'm doing business today will be very, very different, the kind of products and services I will need to be able to offer will be very different 2, 3 years down the road, I have to do a lot more in terms of making people understand how that technology works. So the understanding part is really key, not just knowing, but understanding how it works. The analysis part, not in terms of just how can I use it, but how will my customers use it? How will my competition use it? What will this do to the marketplace? That is, in a broader sense, something that, strictly speaking, on Article 4 is not covered. There's no statutory requirement to understand the impact on the market, but it's a business imperative. And the organizations that do realize that and do put an emphasis on that will be able to prioritize their resources accordingly from both a business perspective and a compliance management perspective, focusing on those types of AI systems that are not just a proof of concept and might generate a press release, but are part of the new business model. And accordingly, we'll need a lot more focus than was just a marketing gimmick. So in that sense, I think we're challenged, and large organizations in particular challenged, to truly get our hands around this and truly appreciate the amount of change this will bring, because only then are we able to build something today in terms of compliance structures, compliance processes that is actually sustainable and will still be relevant in 2 or 3 years.
Thank you. Really interesting. And Dr. Dürrager.
Thank you very much. Thank you very much for the invitation. Now, what can I tell you what you have not yet heard from the keynote speaker, from my esteemed colleagues? Perhaps I can remember that 7 years ago, I organized a seminar at our law firm dealing with artificial intelligence, so long before ChatGPT was launched. And I invited Bernhard Nessler, a speaker. Perhaps you might have heard his name. He's a professor at the Technical University in Upper Austria. He has written with Professor Wenderhurst an article about the definition of AI, or very critical perspective on the definition of AI system in the AI Act. And during and after his speech, the full room with about 100 participants was really confused about his slides he's shown to us, about his speech he's held, and about his explanations about how AI works, about this. Just, I would say, as I can remember from my school time, the probability calculations. We were shown slides with just this probability calculations and nothing else. And these pictures from the cats and the horses and I think you all might have seen before. And this confusion, what artificial, or the explanation of artificial intelligence has raised in this room, I think is still the same. And it has not really changed that much. And
even not if you're talking to technical experts. There are very different views about artificial intelligence, about the term, about what it includes, about the different types of artificial intelligence. As you also might know, AI as such is not a legal term and also not really a clearly defined technical term. It's just a component of computer science, which specifically deals with training or with learning machines to be trained on data and information similar to we human beings do. And this is a science which came across years ago, and Turing was speaking about this 1950. And so I think the main focus on AI literacy should be the distinction between the different types of artificial intelligence systems, between AI system, between models, between neural networks and other methods of machine learning. It's really important first to understand what artificial intelligence is and how it works, what machine learning is and how it works, what the different phases are, and not just to speak about the challenges and the risks we have to face with one use case. There is not only one use case. And this is, we are asked about the appropriate level of AI literacy. For sure, not all employees of a deployer or a provider must be educated in technical questions in that detail. But first, I think it's important to distinguish which people are really dealing or deciding which products are purchased for our company, for which purpose we use which AI system. And this these persons, this group of persons must completely understand how it works. And then on the next step, we can talk about how to use this system and how we interpret the output. But this is really the very last step. After we have decided to buy an AI system, and if this is an AI system or just an algorithm, a software algorithm, as we know since several years, and no one has ever thought about regulating such a software algorithm, which also could have sort of automatism. And not only AI is acting with level of autonomy, also software systems, as we know from years ago, can do this. And this is something what I really miss in the discussion about AI literacy, that we first have to find a kind of basis, knowledge basis everyone has in technical aspects, and artificial intelligence and artificial intelligence systems are really very complex systems. Yesterday, on Wednesday, I had the pleasure to meet a technical expert who has studied mathematics, and he held a lot of patents in dealing with neural networks, and even he told me that weeks ago he was really astonished because in China they have developed a new type of prompting. So the new world of artificial intelligence does no longer prompt as we know. So you ask your AI system, and then you modify your input, and after 3 or 4 prompts, you then have the perfect answer. This no longer is the way we speak to AI systems. In China, they now use it or call it reasoning. I'm not sure if I have fully understood what he tried to explain to me. And I think, so this is, when we talk about the appropriate level of AI literacy, we should really not forget to think about this technical aspect and to try to bring this understanding and knowledge to our employees.
Thank you. It's so great, and it's so important to hear from all of you from your experience and practice, and that this is not behind closed doors, but rather in the discussion. I think it's super interesting. My next set of questions would be, how can AI literacy be used to prevent becoming the provider or developer of a high-risk system? And also, how can AI literacy help mitigate risks under the GDPR? And if someone wants to start, otherwise.
Happy to volunteer on the first question. The AI Act is, as was mentioned at the first panel, at its core, it's product safety regulation. It should be acknowledged that many AI systems are not, strictly speaking, products, but services. The AI Act doesn't care much, kind of throws it all into one bucket. But still, at the core, it's product safety regulation. The problem here, however, is that the type of product we're regulating, in many instances, can be used for many, many different things. It's of course, a hammer you can put in a nail or so to do nefarious things with, but an AI system presents a whole different level of problems in that regard. And the AI Act anticipates those problems and addresses them, in particular as regards the misuse of an AI system, in the sense that as a deployer, you decided to use a certain AI system that was developed for certain purposes. And for others, it was not intended. How do you know? Well, the instructions of use will tell you. Instructions of use that any provider has to issue with an AI system will tell you as a deployer what you're supposed to do with it and what you're not supposed to do with it. Many general purpose AI systems, in particular Microsoft Copilot, allow you to do, well, everything. You can ask Microsoft Copilot which of my direct reports responds to my emails the slowest. You can do that. That's not what it was built to do. And certainly come August the 2nd, 2026, the instructions of use will be very, very clear that this is something you're not supposed to do with Copilot, because that would take you into high-risk territory under Annex 3. So what in practice we already see as a very significant risk arising in many organizations is an AI system being deployed without the sufficient literacy built around it with respect to that particular product. People need to know what that particular AI system was procured for, what it was meant to be used for, and what not. Otherwise, as a deployer, you end up using a system that was licensed as non-high risk for a high-risk purpose. And Article 25 is very clear what happens then. And that is, as a deployer, you become, under the law, a provider of that system. And since you're using it for high-risk purposes, a provider of high-risk AI systems. And that is simply triggering a whole bunch of obligations that, as someone who has just licensed this software, you are in an impossible position to fulfill. You just can't. So the moment you are using, in particular, general purpose AI systems that were licensed for non-high-risk purposes, for high-risk purposes, you're done. You're basically done. There is no compliant way out of this. And the only measure that mitigates that risk is literacy, making people understand what it means to ask Copilot certain questions that simply have to do with the assessment of performance of employees, to give one example. And that is where I think one of the big benefits of having an AI literate user population can come in, and the AI Act, in this respect, makes the legal consequences of not heeding that lesson very clear as well.
And Lucas, so I fully agree with what you said. And to add to that, so in practice, another practical example. So I think one of the most difficult operational challenges that especially large companies face in relation to the AI Act is really to understand, is to first map what AI systems they have in place. And second, is to categorize them, whether they are high risk, whether they are prohibited practices, or whether they are low risk, or whether they are GPAI. So, and usually if you're a large organization and you are sitting in the AI or compliance or even legal group, well, you will need the business to help you with, to identify the AI systems that are being developed or deployed in the organization. You cannot do it on yourself. And so you will typically help the business with the questionnaire. You will provide guidance, but generally speaking, not in all organizations. The people who are supposed to answer to that questionnaire and then to provide information in relation to the AI system that they develop or they use, they are not always the most AI literate ones. So this is what I think. That's why, to answer also Adriana's question, AI literacy really plays a key role so that this staff, they are in a position, or they are able to understand what AI systems they are referring to. One problem already with that is what Sonia mentioned. Well, I really, in order to understand what AI system means, I had to co-edit a 1,500 pages book. After that, I understood. I think I understood finally until I read the European Commission's guidance. But so it means what I'm trying to say is really, especially in relation to in order to differentiate AI systems from traditional software, as Sonia was mentioning. Sometimes the line is not that clear. It's not that it is. It may be blurry a bit, especially for those who don't really understand the intricacies of the legal terminology and so on. So, for instance, if you are an investment firm and then you are just calculating the average share price of the last 2 or 3 years of a company, and then you predict a share price of the upcoming year based on that probability. Well, some companies out there could say that, hey, I have all this because it's a fancy word and it's a hot topic. Hey, I am offering, AI-powered investment advice. Well, it is not actually true. It is just a statistical and mathematical calculation you are doing. This is not AI. But if the people, they are not, of the staff especially, if they are not aware of what AI means, and one of the components of the AI system is inference, and based on machine learning and supervised learning, unsupervised learning, and so on. But some people, they can already identify this already in an AI system, which is not. So I think already, in order to identify whether a tool is AI or not, you need to have some basic understanding. Second, also after understanding the AI, you still need to categorize it, whether it falls in the prohibited practice category or the high risk category or the low risk or the so on. So that requires additional understanding, which is not always obvious. It's not immediate. So I think AI literacy, by raising and providing sufficient training and raising awareness in the organizations, you will be able to also properly identify your AI systems that are using and that you are developing, and then subsequently you are able to categorize them, whether they are high risk or prohibited or low risk and so on. So and you can only do that through literacy.
Maybe to add to that a little bit, the bigger regulatory picture, because we've now been looking at the AI Act, at the risk pyramid. We see, of course, that depending on the purpose we might use that system for, the risk categorization changes, and it's better to be literate than illiterate. But now imagine you're in the low risk, no risk category, and you use that system for a low risk, no risk purpose. So nothing shifts in the AI Act. But here I think it's very important to understand what the AI Act can and cannot do. It is a product safety regulation, as we heard, so it mainly stipulates how AI systems shall be developed and deployed, which still does not change the existing body of the regulation. GDPR was already mentioned, that still determines if we are allowed to use that personal data we might have collected. Copyright laws still exist and determine if you are the author of a work and how kind of like you can become an author, and usage rights and so on and so forth. So, and in particular here, this more holistic concept of AI literacy comes into play, where you need to understand in your context also the bridges and links to other regulations that might be in place and that might apply. So maybe your sector regulations, if you're working in energy or medicine or in the financial markets. Copyright laws, very important when you design media with AI, to understand if you can have usage rights, or if no one has the copyright, or if the machine is actually the author of this work. And to understand also the data aspect, because we know the GDPR is something also to consider, in particular with personal data. We don't like the GDPR much, but still the fines are very high, and also something to keep on the radar. And that is why we also very often advocate for a holistic approach to AI literacy. So not only understanding the AI Act, which is of course currently in the main focus as a new piece of legislation, but also looking at the system more broadly, how it is used in the organization, and how it also may have implications in other legal acts. And closing with something positive, I think Lucas already underlined very nicely that we also need to understand and look at the opportunity perspective, because something and some tool we do not understand, we cannot fully benefit on the opportunities. We end up sending around some AI-generated emails, let my AI agent call your AI agent, and they fix some sort of appointment. But you need the literacy to really leverage the power of this technology and understand which tech to use for which kind of problem, and how to deeply transform your business and not only automate communication.
Dr. Thürager, did you experience similar in?
Perhaps two aspects. One, to the question regarding the high-risk systems. It's very important when the developer decides or develops a system and knows it is a system that is classified under Annex 3. It's an area which belongs to this Annex 3, but he tries to describe that his system does not fulfill this high risk and is, even if classified under Annex 3, not classified as high-risk system in the sense of Article 6, Para 3. He then has to document why this is the case. And for this documentation, in order not to be in the scope of the AI Act, and this is a very important view of many developers now, that they have, even if they have a system that deals with, for example, employment issues, it does not represent this high risk. And for this documentation, for this weighing of arguments, it's really necessary, absolutely necessary, to fully understand not the technical aspect, but also the AI Act as such, this Article 6, and what is high risk, and how are all these exceptions and counter exceptions on the other hand of Article 6 be interpreted. What is profiling? And this is important also for your second question, this mitigation of risks under the GDPR. Profiling is something we all know, and also our employees know from the GDPR. And so it's important that the people who deal with AI systems understand the GDPR and the AI Act with regard to topics that are dealt in both areas and that influence each other.
I'm now not talking about the relationship between AI Act and GDPR. It's a separate topic, but they influence each other, and it's necessary to understand the data flows, which sources we use, which data we use, are the data personally related or not, are they anonymized or not, do we need personal related data or not for training the system, and how could we anonymize data? Is it possible to synthesize data? And these are all questions which need, on the one hand, very deep understanding of technical measures, technical methods, the technical circumstances, and on the other hand, all the legal topics, not only AI Act, also related acts like the GDPR. And also one issue I think is very important also for mitigation risks under the GDPR, but also if we think of the technical and measures in order to safeguard the data, NIS 2 directive is very important. So also the people who are dealing with cybersecurity, with IT security, with AI security have to be familiar with GDPR, NIS 2 directive, and the similar topics which are dealt in all these digital acts. And so it will be very interesting how these training of people dealing with AI in a company will work at the end. It takes really a long time to have transported this knowledge or to educate the people accordingly. And I think we've already heard from you, Jeanette, that it's very important to not forget that the systems and also the jurisdiction, also the court practice develops, and hence it's necessary to regularly educate the people, not only as we have done, or most of the people, the companies have done with the GDPR, just to educate in 2018, and then we've stopped. It's really important to educate regularly, because there is a technology behind which evolves and develops very rapidly, and so 1 year, one time a year, I don't think will be sufficient as such.
Thank you. Some really essential points have been touched, and I could go on with way more questions. But at this point, I think also a lot of people in the audience might have some questions, and I would give the floor to the audience to ask and get them more correctly.
The only thing standing between you and the drinks over there. So very, very briefly, thank you to everyone for coming. Thank you very much to the panels. Very happy that we started the debate. I'm quite sure that it's not the end of the debate. Please stay with us. We will have some coffee, tea, drinks, and some food served here. And please stay in touch with us when it comes to the further debate, with everyone on the panel, with everyone among the authors that was here today, and also with our department if you wish to do so. Thank you very much and have a good evening.